Check your this shit.
My
Check your yeah, we're here.
check my what?
Check your YouTube.
Oh, okay.
I see myself there, so all right. So Macadamia, I've never done this way before because it's not really a consult or what have you, or some kind of expression of things. But we were discussing some things offline that I thought would be beneficial because I don't know how to evaluate me for other than who I am and what I've done. I could get into back and forth with people and they'll come on, especially after they see this live because it's open to everybody. And I know you know how to work these things better than me. So if you can pull up on another screen that you can see if somebody comes in because we're live and it's
Let's see. Well, I can pull up the live to watch while we are.
especially after they see this live because it's open to everybody. Things better than me. So if you can pull up on another screen that you can see if somebody comes in because we're live. Probably mute that too.
Let's see. Okay. Wait, talk? Because I want to
Yeah,
make sure. Okay,
I,
yeah,
there you
I'm
go.
gonna mute I'm gonna mute the video so that there's not
There you go. So now I can
double
see. So if
feedback.
somebody comes in and they'll probably have some things to say. I don't care about people hopping in the chat. I'm not that kind of guy. And knows it's not disrespectful. And
I don't really care
whatever.
either.
So okay, you have some questions for me. I know you sat in on a couple of my and let me say this before I get started. I'm not an attorney. I don't have a license to practice law. I do not practice law. What I've done is study the law based upon my circumstances and share what I've learned based upon my experiences. So I don't give advice to apply to anybody's specific case, but it's general information regarding the law and lawful principles, which, by the way, belong to the people. So please use any information that you may see on this video for educational edification only. And the reason I say that is because I want nothing that I say to be construed to be legal advice. If you feel you need legal advice, I highly encourage you to hire a licensed, hopefully competent attorney and be legally advised. That being said, I also highly recommend that people seek the counsel of attorneys. And I do not say things disparaging about attorneys, typically. There may be some that I may say something disparaging about, as everybody who's watched me at city council meetings knows. I'll drop names and what have you. But generally, I think getting a well um, getting an attorney is beneficial for most people. And what I don't do also, I don't know what this thing, it's like it's off a little bit. It's like on the opposite side. Um, I don't recommend that anybody have to go through things the way I had to go through things and had to learn the hard way. I couldn't afford the kind of representation that I needed, and in many instances, attorneys would not help me. Which is how I got to where I am with the voluminous in court appearances. He's not a I won't say he's not around. He's probably somewhere asleep or doing something else that most guys do. Will Crowley is who brought me to doing what I kind of do for you all now in some regards, because he is the first person who ever showed me what he went through in a court proceeding, and also he was a person who was studying UCC. So I would tell everybody to go to my page and find where Will Crowley is, where I do the interview, and he tells you what he went through when he's doing the UCC teachings and when he was doing what do you call those things? I think it's bills of exchange. I'm gonna try to get him on. And he showed it to me. He's like, Greg, everybody will tell you all these fantastical stories. And by the way, this is about 12, 13 years ago when I first started coming into some of this so-called information that people are still seemingly trying to use that doesn't work, or that I haven't seen any proof that it works, particularly the way that it's sold to work. So that's what brought me here. And another thing I don't do is I don't recommend anybody put themselves in a position that would be detrimental to what word you used earlier, like self-preservation. I don't
Yeah.
suggest that people do what I've had to do as far as self-representing. It's because in every one of those cases where I had that driving without license, which I was willing to suffer the consequences to go through the court, I was facing jail time every time. So those 12, 13, whatever they were, I was looking at jail time every time. And the reason I'm transparent is because I think there's a bigger issue out here, especially as it relates to me. There's something, it has nothing to do with child support. They're using that maybe as some sort of subterfuge for a bigger issue because I don't think that they want people to be, and some, I shouldn't say there are people within the system because the system is fine. If the system wasn't fine and the law wasn't fine, then how would you explain me?
It's just not as bad. It's just not as bad as it could be. I don't know about saying like the system is fine. I definitely think that our system has degraded down to something that we definitely don't want it to get any
Is
further.
that the system or the stewards of justice or the stewards of our system who aren't doing what the rules require them to do? That's different.
I see that there's nuance there, but I see it as a bit of one and the same. Like, and I've told you that I've been reading like the Federalist Papers and other historical documentation to understand like the underpinnings of why we have the system that we have. But, it does is the way that the system is designed great? Yeah. But then, like you said, the stewards, I don't know, like yeah, I guess I could concede and say that it's about the stewards that are, holding the positions of authority to operate the system is more the issue. But, I've been pondering on this quite a bit because, corruption and um, the potential of being pulled towards doing fraudulent things. We're all human, so I don't know how to especially like we've talked about like I watched that video that you posted about your judges that one judge's public reprimand or
Greg,
admonishment.
Judge Gregory Holder's public record man, yeah, reprimand, yeah.
Yeah, but that stuff doesn't necessarily. I've been watching a bunch of videos I probably shouldn't watch because I'm about to be going up against or going into the courtroom, and I just can't have this negative tone when it comes to thinking that all judges are just.
I don't think all judges are corrupt. I think that there's rules, there's exceptions to rules, and there's exceptions to what is expected of a public official. And what I say is there are guardrails that are in place. Why those guardrails have seemed to have fallen off because of with some of my situations, I don't know. I have reasons to speculate. I just pointed to him because specifically I can show where he had an issue, and by proximity, because I'm still within that circuit, people who actually serve with him or work with him may have some biases. But if you were to ask me, hey, Greg, pull up an issue like, say, a particular case, say the Smallwood case, anybody who had taken the time to look at it knew what the issue was. I have nothing disparaging to say about the individual person because the state of Florida pushed a case where they had no jurisdiction. Quite simply, I think May 15th, 1996, they filed a document. They didn't serve it within 120 days. They never got extension of time to serve from the court, nor did they show good cause for not serving the initial summons and complaint. They amended it twice. That's an unenforceable order, not because I couldn't waive jurisdiction because the so-called petitioner had no minimal context with the state of Florida. So whatever state that they may have come out of, which wasn't Delaware, which is kind of interesting in and of itself, the Delaware issue was what? We don't know, but we know one thing: she didn't live in Florida. So when I asked the question, which anybody can see on what was the master class, to the attorney for the state of Florida, the assistant attorney general, is it your position that Monica Smallwood filed that case in Florida? She said yes. Everybody knows that now that's a lie because she's not been in Florida. We also know that by simply looking at the record, there's no complaint that go with the summons. So there's no way that you could assert a summons and complaint. And I did mention McIntosh, who was responsible for filing child support cases in the state of Florida, were involved in some pretty shady activity to secure certain child support orders. Now, my eyes 20 some years ago aren't the same as my eyes today. And when I brought it up, and I just was transparent with it because I understood, which is probably why the hearing officer filed a letter of recusal, correct? These are things
Probably.
that everybody can, well, we don't know why he did it. We know he did it, all right? It's evident he did it. That's in the record. And anybody who would sell it as something other than what it was, that anybody can go and look into, that might be a person. But at the end of the day, the rules stated what was supposed to happen. When it didn't happen and you bring it to somebody's attention and they're a steward of justice and they don't follow it, that doesn't make the system bad. It makes that individual bad. And what I would argue is that within the rules, it should have been corrected. Our question as citizens is why we don't hold our public officials to account. Now, I've written letters to the bar associations about these people well before the bar sent me a damn letter, which we were all trying to figure out. My disclaimers are everywhere, right? Why didn't the bar investigate these people? Why haven't the bar investigated All-Star Row Basketball Professional Association for hiring a VA doctor to conduct a compulsory medical examination on a veteran and not disclose it to the veteran, then file documents for that doctor who you don't represent because you were representing the insured of State Farm Insurance Company. You didn't file a notice of appearance for that doctor. You filed a notice of appearance for the people who I alleged hit me, who State Farm's attorney filed a notice of negligent admission for after I deposed the lady, and she said she hit me on with a rolling stop. She saw me, she had control of the vehicle, she did a rolling stop into my vehicle. So these things are established. We go through a mediation process, right, Macadamia?
No, I'm tracking. I'm tracking.
Okay, well, you've seen it. The stipulation of the parties is not a mediation settlement agreement. I signed a stipulation. And the conditions of the stipulation were that you're going to pay me $30,000. What he did was show me the $30,000 check. He didn't show me the check. He agreed to $30,000. I agreed to the $30,000 under condition that it applied to one case. He didn't give me the $30,000. He came back and then he drafted a two totally different release. I'm talking about Michael Rowe or Austin Rowe Basketball, the whole professional association, and says, sign this. And I'm like, well, I'm not signing that. Then I have a judge, Emily Ann Peacock, who says, I'm ordering you to sign it. Well, now it's not voluntary. But when
Yeah,
we
what is up with that? Like it boggles my mind that the state can compel you to enter into something like that
they
when it's
by law, they can't.
they can't or can.
Cannot.
Well, that's going to be an interesting component to my case too, because I understand like what you said about, being a general and well-established legal and lawful principle that you can't be induced into something. That's just not the way the rule of law works. But I've seen it, I've heard it, and I've heard your instance of it, and I've seen it in multiple YouTube videos where judges force you to sign something, and that would be under duress. And typically under like UCC, if you put in there like under duress, that should make it so that it's
Well,
not binding.
let's look at it this way. When we say UCC, UCC is contract law. We all understand that.
I
And
understand that. Yeah.
so let's do this right here. And let's go into what we have that many people probably don't have the same of, and we'll pull up our little machine that we have, or a couple of them that we pay. I say we, me, pay or have that we pay a lot of money for, right? To
I don't know
be
how much you pay for the AI stuff. Yeah, the assistant. I've been trying to build one locally for myself.
you're in what state? Washington, right?
Yeah, Washington. Oh, I
Uh,
know. Sorry, it's 62A. 62A is the
it-
UCC in Washington. Or okay, can a
a release to resolve a civil. Let's try this. a civil matter. Can compel a party. Let's try. Let's just get it this way. But let's go right here. Why is doing that? Let's see if Washington law gives them that.
I'm kind of afraid to see what it has to say.
Now that's interesting. At the time, they were neither parties to a lawsuit nor any claim to settle. Let's see this. Well, there you go. A judge will be an arbitrator.
But that's with my
But
viewing of
but
Washington
see,
state
here
courts,
you go.
a party cannot be required to arbitrate. He or she is not agreed to arbitrate. That's interesting because I've actually seen judges force people into arbitration.
No, they can. Well, I don't know how you can force.
Well, you
Courts
order it. You
have
order it,
their
and then
time.
they hold you in contempt of court if you don't go to arbitration. Preclude the party from claim relation, attempt, burden, a contract impose, any international. Hmm.
Your question, I think, is here, isn't it?
CJC 2.0, a judge may encourage parties to proceed to settle matters in dispute, but should not act. That is interesting. I actually, I need to write that down or I need to note that. Uh, Code of Judicial Conduct. Code of Judicial Conduct. And that's 2.6B. That's interesting. I'm just telling you what I've seen on YouTube videos and actually what I've seen in courts when I actually walk in. And I spent like a week going into Pierce County's Superior Court just watching hearings just to familiarize myself and get past like the hurdle of kind of being afraid of going into courts. And I definitely saw some not judges but commissioners, pulling the weight that I'm the judge and you're going to do what I'm going to say. You're going to do what I say.
Let me say this as a as an unknowing party the to a proceeding. If all the facts are not known to you, then would it not be speculation to presume that you understand all of the important components that brought whatever, if you walked in on something without being fully abreast of what's going on, you may presume something or assume something that may not be accurate. And what I would say is be careful with that. If you can articulate specifically, then we may have somewhere else to go. And that's where
Hmm.
I think um what I've was had the benefit of learning for years, and I'm kind of bringing up. And by the way, this is just part one of us doing this. Um, so I would just say be careful. But as you can see, and I'm pretty sure that would apply in almost any state because the judge is not a party to the action unless you agree again. Because there's some uniformity, and when people ask me a question and they're in another state, I say, "Well, I can't give you legal advice. I don't give legal advice." But I would say I just can formulate a nexus. I formulate my nexus typically either by my own personal experience or something I've seen, and then I say, "Okay, now let's get the facts." Now you can know what the law is, but what are the facts? Because what's the issue and what's the rule, and how did you bring the rule and the issue together to conclude that this is the end result of it?
Hmm.
And
No, I get what you're saying with regards to like my judgments
no,
without
not just what
knowing.
you just said.
Well, either what I said or my conclusion about what I saw. Like I don't know all the details about the whole litigation and stuff like that because it could be the case that the dude who was being seemingly railroaded, had frustrated the case and it was reasonable for the judge to be laying down on him as I saw them. But in my understanding that really shouldn't be the case. But like you said, I can yield and say that I don't know all the facts surrounding the case and the situation, but I've been spending some time reading the Code of Judicial Conduct as well as the Attorney Rules of Professional Conduct, because a part of my case and the fraud within my case, I'm going to be using complaints.
Alleged.
What's that?
The fraud alleged, the fraud you mean the fraud you alleged in your case? Because you said the fraud in my case is a conclusion, right?
Yeah, that I'm going to support with evidence.
So, but when you made the statement, you said the fraud. I'm not saying that there is or isn't fraud. I'm saying, but wouldn't it be probably
Sure, I'll
good?
be alleging a significant amount of general misconduct that can be portrayed as alleged fraud. Washington State judges. Settlement agreement. Well, but I'm just telling you what I've seen. To me, it looks like in Washington State they've merged they quasi do arbitration within public courts instead of
Read the full statement.
in Washington State, a judge generally has the authority to compel a party to sign a release or resolve civil when the parties have reached a valid settlement agreement, but this power is subject to specific procedural requirements and the limitation regarding what terms can be enforced.
Stop.
No, I get,
Stop.
I get.
So now, that's not just one thing. That could be multiple issues within a specific situation. And I would love for attorneys to come on and just kind of help us out with this. I don't, I think that they could provide some sort of clarity, court authority to enforce settlement agreements, and it kind of breaks it down. You see that?
Well, that doesn't confuse me about being able to enforce a settlement agreement because the settlement has established some sort of agreement that you're enforcing rights, and the courts have an inherent ability to help a litigant or a person enforce their rights.
Watch
So
this.
I don't have an issue with that.
But hold on. What state
For what? What are we asking? Is a settlement or
is a stipulation of the parties the same as a mediation settlement agreement? What state am I?
oh
What state am I?
oh I mean we could do Washington State again. I mean
What state are
I
we
want
looking at? What state are we looking at now, though?
Florida. Okay. Okay, stipulation of the parties are the same as a mediation settlement agreement. Yeah. Let's see what AI has to say.
Well, it's going to bring you some case law too. I guess I could do both of them at the same time. And that's assuming that this was actually done.
Yeah, that's the thing too.
And so the thing is, what question are we asking? And in asking,
Are not the same. A stipulation of parties in the mediation settlement agreement are not the same under Florida law, though they share similarities in binding agreements between parties, while both represent council resolution of dispute. A
central,
mediation settlement
central.
consensual, sorry. A mediation settlement agreement is subject to specific statutory and procedural requirements that distinguish it from a general stipulation.
So, so to help you out now, when I showed a stipulation of the parties and he brought a release that was supposed and their claim is the mediation settlement agreement and the exact wording is the same, it's not the same document, is it?
It's not, but how do you, so for instance, like in my case, they didn't call a particular order that I got in my case as being a declaratory judgment, but for all intents and purposes, in in its effectiveness, it was a declaratory judgment that they didn't title it that. So like the legal nuance is important, but one aspect that I dislike and that I'm dealing with in my case is them not calling something what it is, but using it in the same function.
Okay, so what question do you think we should be asking?
Well, so like if we bring it back to the stipulation of the parties versus a settlement agreement, functionally they're the same thing, but there's some sort of nuance that makes them different. And I guess it's the procedural component to establish it that makes the difference. Let's see, civil 2A
It's
governance
your
enforcement
situations. I'm just trying to help guide you through it.
to agreements and consent between parties and attorneys in respect to proceeding in a cause the purport of which is disputed will be regarding the courts by the court unless the same shall been made and assented to in open court, a record entered into the minutes, and unless the evidence thereof shall be in writing and subscribed by the attorneys denying the same, the Superior Court Civil Rule CR 2A. Similarly, RCW whatever requires the agreement to be made in open court and in presence of a clerk and entered in by him or her or signed by the parties against whom the same is alleged and her attorney. So that's interesting because I had a hearing that they canceled my hearing and the clerk was trying to induce me into signing an order or an agreement to go to our mediation with the other parties to my case.
Hold on,
Um,
hold on. So here's where we are. You saying trying to induce you. Just listening to what you said, what would make you believe she was trying to induce you?
well, we can do it in the lens of like the racial lens because she was like,
Oh,
I refused I refused to sign paperwork because I wanted to go to trial and I was set on going to trial to fight to assert the facts because I knew that I was going to have to I know that I have to fight this out in the higher courts, but they were trying to get me to sign to go to or not arbitration but mediation with the parties. And she said I have to sign it and I told her no, I don't have to sign it. And she tried a couple different things. She was like, if you sign it, I'll make you a copy and you could have it for yourself. And I was like, I don't agree to go into mediation with them, so I'm not
hold
going
on.
to sign
Wait,
it.
whoa. So let's do this. Let me try this.
So what is inducement? Yes, under Washington state law, parties can be forced into mediation.
So stop. You can go to the mediation, but the question, that's not really your question. Your question is, can they force you to resolve a matter in mediation, isn't it?
Yeah, I think there's some legal
Mediation
nuance
could be, in
there.
other words, mediation can be part of the process.
Yeah, and I understand like there's normally like settlement conferences that are required in Washington state under Washington state law before you even go to trial.
Okay, so here's the question. I didn't say a 10 can be forced to resolve.
No, under Washington cannot be forced to settle in mediation. It's a voluntary process, mutual agreement. Yeah, there was no mutual agreement, and that's what I was trying to express to her, and she kept on trying to get me to sign
Who's the she? She who?
the clerk of the second judge that was assigned to my case.
So JA, right?
What's that?
The JA.
The judicial assistant, yeah, or clerk, yeah.
So your question is, under Washington law, can a clerk do what? What's she trying to do?
You can call it inducement, coerce, cajole, like however you want to get it. I refuse regardless because I know I didn't have to like no one can force me to agree to go to mediation, especially not with the circumstances and the
Wait a
fact
minute.
pattern of my
Wait,
case.
wait, 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 wait. You just conflated two issues. We've already answered the first thing. They can force you to into mediation. They can't force you to resolve it. So now she was trying to get you to agree to the mediation, correct?
She was trying to get me to sign a piece of paper or an order that required mediation.
Okay, stop. We got that resolved. Okay, she can have you. So now I'm hearing something a little bit differently or a little bit more clearly. Your thing is you didn't want to go to mediation, you wanted to go to trial.
Yes.
Okay, stop. So why not just go to mediation, not resolve it, and still get your trial? You just want
Uh,
what you want to do is you want to satisfy the process.
I did. So I tried to get into mediation at
And
the
I'm not
beginning
giving you
of the
legal
case.
advice. If an attorney, if you ever get this, hopefully you can watch this and say, I don't know why you wouldn't have gone to mediation. I didn't say that I would refuse to go to a mediation because I may get what I want at the mediation, and it could benefit me. But if you close your ears to it, you're not even willing to hear, and they're saying what they're doing is the state of Washington, the legislature of Washington, I'm presuming, established a procedure, or actually even Washington Supreme Court established procedures that regulate and govern yours is domestic relations case.
I'm not sure what to consider. It should, I guess. That's
Hold on,
I don't
under
know what other
Washington state
category.
law. What? Okay.
Yeah,
What?
it would be under the domestic relations statute, which is 26, Title
What?
26.
Okay. I just, but why? Okay. Because we're not just talking to ourselves, are we?
Oh, no, no, sorry, yeah.
Uh, is it a domestic relations
Yes.
case to establish what?
Parentage or paternity.
So there you go. So you had your own answer. So if it were me, and of course I don't give advice, but if it were me, I would find what my issue is. My issue is I don't want to go to mediation, and can Washington force me to go to mediation? So then I look for the rule. Now, if my argument is I don't want to go to mediation, the question would then be, it does a refusal to mediation, if it were just me and an attorney could do better, does a refusal to attend a mediation conference to resolve a parentage um, determination constitute a waiver of any rights? Why the fuck? Who cares? There you go. You want to read that
And
for everybody?
let me make it bigger. Let's see. So, yes,
Whoa,
refusal
whoa,
to
whoa, whoa,
attend.
whoa, whoa, whoa. He brought me to Florida. Why do you think he brought me to Florida? That's where I'm located, right?
Yeah.
There we go.
Isn't an automatic waiver of all rights, but it is a serious issue that the media. that the mediator reports to the courts, potentially leading the courts to sanctions, attorney fees, and case proceeding without you. And mediation is often mandatory locally in family court matters or family law matters, while state law encourages it. Local rules often require participation, and a judge can view your refusal as unreasonable, impacting your case negatively, even potentially affecting costs or how you're perceived, rather than immediately waiving fundamental rights, like the right to parent. Now, the thing that, my case is peculiar. We've talked about how some of the oddities to my case, but like my specific response to this stuff is I've already read the statutes, and I know if domestic violence is a part of of a domestic relations case, then the courts should waive automatically any requirement for mediation. And that was what I was attempting to tell them. And and all for all intents and purposes, this is speculative and a presumption. They knew that there was
That,
domestic violence in the
whoa, whoa,
case.
whoa, 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 whoa. Did you ever attend any of our classes? Barbershop talks?
No.
Um, we don't speculate when we can otherwise find the answers, right?
Um,
What am I
the
doing now?
reason why, what's that?
We're not speculating. We just try to find. We're not speculating in what you're talking about, are we? We're just saying
Mm,
if you have a question, there's no need to speculate as to the answer if we can try to narrow our pathway to getting the answers, right?
sure. So when I was
This ain't
invoking,
even about law. This is about I think I can dunk. Well, I could speculate on it, or I can go up there and see if I can dunk. I can go find out the answer. Give me a
no, no,
bat.
I was speculating what they potentially know. Like I can't say that the clerk herself knew about the particulars of the case. That's the only reason why I was bringing in the notion of speculation.
You
Or
saying a clerk? Are you saying a judicial assistant? Or you mean the clerk of the courts?
they refer to them as they are judicial assistants, but they call them clerks
Oh,
also. So
oh, a judge's clerk. Okay,
a
I get it.
judge's clerk.
Okay, okay. It's like the judge's secretary is what it is. Okay.
Yes. So they,
Now
you've got
hold
the
on.
clerk of the
Is the judge's secretary a clerk, meaning a person who can actually do the research for the judge, or is she just a secretary that has just like nominal secretarial duties, like she files documents, she types, she answers the phone, or does she like is she like a magistrate under a judge, or is she just a person working in an office that says, "Hey, listen, in order for me to uh move your case along, I need you to sign this document, go to mediation, so that we can." Okay, here we go. Under Washington law, let me do this another one. Under Washington law, can a matter be set for trial without mediate? Oh, motherfucker. Read the question.
under Washington state law, can a domestic relation case be set for trial without mediation? Yes, under Washington state law, a domestic relation case can be set for trial without mediation, especially if there's good cause, like documentation of domestic violence. That's exactly what I was going to say.
So then, so she said, was there documented domestic violence?
I
Look,
so
or if
yeah,
local rules allow for waivers, but often mediation or a settlement conference is required first, particularly for child-related issues. Read the whole damn thing.
okay, or if local rules allow for waivers, but often mediation or settlement conferences is required first, particularly for child-related issues, with courts having a power to compel it or grant exemptions for safety. Okay, I I understand that.
Okay, so now here you go.
I get that.
So now, what we want, this is what I was, one of the things I was taught is issue spotting. Spot your issue and then ask the question. If it were me, I would spot my issue and I'd answer the question. I learned that from attorneys. It
I
don't.
get that. So the issue would be with it being the case that there's domestic violence in the case, and the domestic violence is quasi like perjury and manipulation
Whoa, 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 whoa,
of
whoa,
a
whoa,
narrative.
whoa, 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 whoa. That's the conclusion.
Okay. Well, how do you want? How,
Not how
okay.
I
So
want. You're concluding that this is the reason.
yeah. So if this, then that.
But how does that work with the law?
Well, with these set of fact patterns, when you reference this rule, you come to this conclusion. That's, the IRAC method. So if
Right.
you want
But
me to start out,
then the court makes a determination, right?
uh, yeah, based off their perspective, but I still plead out my perspective and appeal if I disagree. Sure.
Okay, but then the court has to make a determination. You're making the court's determination. You're making a determination that you don't have the ability to make. You're saying this is what is established. Well, did the court establish it, or are you stating this is what I think happened? I allege these things, and the court concluded something different.
Well, so the biggest thing about my situation is that I need a court to allow me to enter into the record facts, and then they can make whatever ruling they want to. I don't necessarily, at this point, I don't care about what a trial court says. I'm just set on arguing for new law in the higher courts.
Oh, now, okay, there we go. Now that's something different now. How does a party move to establish it?
I'm not trying to amend a pleading, but I probably should have done that. But
I don't know. I'm not saying one way or the other. All I'm doing is listening to what you're saying, and I'm trying to ask a question that may bring more clarity to your pursuit.
yeah, so you're asking how does a party create new case law?
No,
Like
no, I'm not asking a damn thing. You
what do you
just
think
said,
I'm asking? Sorry, what do you think I'm
I know
asking?
what I heard you say. I
Yeah.
want to change the law. Okay, so how do you change the law?
It's not necessarily changing a law, it's making new law referencing legal principles.
I think it's gonna be the same thing. And this is only based upon my civics background.
But there's more than one way to make a law. There's the
Whoa, whoa,
technical
whoa,
way, which
whoa,
is
whoa, whoa, whoa. I think I don't speculate. I'm too old. We try to just get to the answer, ask the question, and then, I don't trust AI with 100%, but the initiative process, okay, I understand these things because of my academic background. If a motion to amend is granted, moving part, okay, it's different. But you want to amend the law. You want a party move to make new law. Because you're trying to say you want to make new law. And
yes.
we know how bills are passed and how bills become law. I'm just a bill. What comes up, people have an idea, and they take the idea to the local congressperson. The congressperson says, okay, let me see if I can get this into committee and make this a law. Okay, the committee votes on, okay, let's propose it. It goes out in front of the legislative body. If it's whatever the rules are, majority or 60%, 60% says, okay, cool, let's pass it this way. And then also you can create a petition, get enough petitions. I think it's going to be here somewhere.
But
Uh,
that's a legislative process to make law.
okay, but every Law is legislation, bro.
No, it's not. It's not the only way for laws to be established.
You talk. Wait a minute. Whoa, 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 whoa. Are you talking about like how is common law established?
Yes.
Okay, common law is court created law, but don't take my word for
I know.
it. But okay, want to read that, buddy?
Common law is created by judges through decision of the court in a court case, formal judicial precedent, case law that creates your rulings rather than from comprehensive legislative code. Yeah, that's so sometimes you make common law case law that influences the legislatures to make new statutory law.
But
That's
once,
sometimes
once, but once a statute is passed, courts are supposed to follow the statute.
yeah, that's fine. So like that I'm saying that the process would be me doing a common law claim, hopefully winning my common law claim, and then the legislators being made aware of the common law claim to make statutory specific legislation to mull out like what are the defenses, how does it work, what are the elements, where the courts make the first determination that this is a valid common law claim, and then we go through a legislative process to to enact it as a bill or a
Wouldn't that be the
statutory law.
wouldn't that be the long way around when you can just go ask a congressperson to present it? They say screw you. Then because you're saying you want to make a common law claim, but in order for it to be here, are you sure that the argument you're raising hasn't already been addressed?
In previous cases, like is it a moot is it
That means it's previously addressed.
well, what do you mean? I'm trying to understand what you mean by previously addressed.
Okay, I want to know if kicking somebody in the ass is a simple battery or is it an aggravated battery? Then the question could be, is there already a law or already something that addressed it? Because then you're gonna say, what are the elements of a battery? You know,
Well,
what are
that's
their assault? And if it's already been addressed, how you can get there, then you're not creating anything. You're just addressing something. You're just asking the court to rule on a matter based upon a specific set of facts that uh would we well actually you're asking the court to rule on a matter based upon a specific set of facts, period. So when you're saying I
sure.
want to create something new, I'm asking you specifically, what is it that you would like to address? So maybe we can figure it out because the question you have or the position you take may have been taken by somebody in another state or even in your state. I'm just saying, let's see if we can get it figured. Why am I looking at your desk, bro? Okay.
Sorry, my bad. My one of my screens is dead, so I was trying to see if I can get it turned back on. But yeah, so there's one component. You read that my crazy letter. So one aspect is I already know that custodial interference is already a criminal offense. But we run into the issue that criminal codes are enforced by the state.
All right.
So it could be one component that I'm asking for a new common law avenue for civil relief that an individual doesn't have to rely on the state for. That's one thing that I'm potentially asking for, and that's rooted in an interference claim or tortious interference, and asking for a civil right to be declared at a higher court to establish a right of action for anyone who wants to bring that, and then for them to explain what are the elements they would be looking for that lower courts have to look for to establish tortious interference or custodial interference in a civil matter instead of it being a criminal matter.
Well, say what you said again.
Let's see. Is there address common law? It would be so the common law principle would be torturous interference. So like, Yeah, right there. Right there. But
So,
that
so then you don't need to make something new. You just need to have that. I don't know. Attorneys out there, come help my man out. I'm sure you would love to be the one who seems to make it clear to people it's already there. So
but
maybe,
that's a criminal statute. Like I said, it's locked behind the criminal code. So a criminal the state has to bring it. Just like in Title 18 for the federal side.
so wait,
The,
wait, 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 wait. You wanted there to be like, can you, so your question is, can you sue for like intentional infliction of emotional distress?
could be a component to it, yes. Which would be the damages component to it. Yeah.
That's really agreed upon. So, and I don't know, and apparently, hopefully, an attorney somewhere will grab this. I just think what you might want to do, or if it were me, after seeking the assistance of counsel, or at least through consultation, see if I have a this claim that would result in this based upon what she did, or I'm alleging she did. You see how that works?
Yes. So I'm making I'm that's the case that I'm going to be making. And
But there's
and I've
all
looked up.
there is already law there, apparently.
Well, we can you got the fancy case law stuff. I
I'm
looked up.
using the Google machine.
Yeah. I don't necessarily have a problem. I'm not trying to say that it's not a valid concept, and it's not that I haven't found a case that references it, but it's an old case, and I even tried to reference
But
it and bring it
old
up.
case isn't the issue. Your issue is okay. I think, and hopefully, and it's not giving you this as legal advice. I believe what you want to do is to allege that in a complaint,
Yes.
laying out
Yes.
facts that would lead the trier of fact to conclude that you're entitled to this based upon this or some
Yes.
base this arising from this, or I mean this, or and this arising from some set of acts or actions by another party. I just think that maybe you should get somebody, potentially a lawyer, to
Oh, hell
draft
no.
a lawsuit based upon these set of facts. If you choose to go at it yourself, I just think that alleging facts sufficient to allow a trier of fact to conclude that you are right in pursuing a civil lawsuit for tortious interference with your parental parental relationship, and you are seeking monetary damages for emotional distress and other harms caused by whoever the party that's harming you wrongful actions, and which help leverage those elements of IIED. And if it were me, I would say under what are the elements? Well, you know what, here you go. I'm not even gonna say it.
What is the term that describes what do I know? What do I want to know, and how do I find the
Watch
answer?
this. Here you go, buddy.
KWL strategy?
That's
No.
me. But it's kind of like the scientific method or the problem solving method.
No, I get what you're saying, Greg. I know for the most part what I need to do. Um and alleging
We
these
got
things.
somebody. Hey, thanks for joining us, Ron Love. We're in Washington, Ron, but thanks for joining us. Um, and you see the burden is extremely high in Texas where he lives. And what I don't know how much of this you've already had the pleasure of enjoying, Ron. I am under the impression that my buddy here is seeking an answer. He's seeking some sort of a nuanced approach to something that already exists in law. So I think I see what's up,
Well,
Ron.
you know that my case is more complicated than that. So like that is just one component if I am the father of the child in question still. So I think I've already explained to you I'm also entitled to a second genetic test to ensure that there would like the elements of fraud that I'm going to be alleging isn't indicative of something even worse, which would just be paternity fraud.
But hold on. I don't get it. So what I'm seeing is not that you don't have an art. It's almost like and I don't know. We got to be within 4 years of filing the acknowledgement of paternity, so that means there's a process. This is where I'm picking this up, and I know Ron is out there. What's good, Ron? The other issue is I would think if it were me, if nothing else, I would sit down with an attorney and just say, "Look, man, how do I bring this matter before a court?" And they may actually help you. I'm telling you, I've learned, and I won't say their names to protect them because of who I become, unfortunately, or for whatever it is. I think that I think that your pathway is already there. It's like you're saying, like somebody's like my man Ron C, who's jumped in, Ron Love, who's jumped on, and it's like, um, inbox me, Ron, if you want to jump on, and I'll give you an invite to the Zoom. The I think that your path is already there. It's like I get Ron, I hire Ron to go clear out a path. He gets his whatever the little John, I won't say the name of some tractor, and he clears a path to okay, we want to get to that house on the other side. We can see the house, but damn, bro, we need a pathway through there. Ron clears out the path, and you want to go through the brush, and then you get mad because a bear or something grabs you and snatches you off somewhere. I'm like, well, damn, bro, why don't we just let Ron open the path? It's already apparently there because we've done all kinds of uh the work is there.
I don't disagree. I'm not one saying that I don't have a legitimate claim, but I could plead, if I plead out properly, I could show that I'm entitled to relief. But we started out this call talking about the stewards of the legal system. One issue that I was running into is that they didn't want me to go to trial with the facts that I had been trying to allege.
I haven't heard that from you.
Well, there's a re I'm not just trying to go like I don't see a clear path, but then also see a thorn bush, and I just want to walk into the
What
thorn bush, Greg.
Ron Love wants to know what's your claim? What's
Yeah,
your
there's so are you asking, so when you say what's my claim, are you
no,
asking me what
Ron's
I'm
asking.
alleging? Okay,
No,
sorry. Is the question what are my damages or what am I alleging? What is the fact pattern that I'm going to be alleging?
well, I think it's like, what are you trying to accomplish?
Uh, yeah, certainty with regards to the fact of paternity.
Okay, now we have a way of getting there. We're
Yeah,
reading it.
well, no, I understand this. So if you're asking what my claim is, and then how does that translate into a procedural process? That's me bringing the claim and then asking for a genetic test as a non-dispositive motion to get the second genetic test and find out if I actually am the father. So that's just one component to the larger lawsuit.
Wait. You want to determine, can a were you married to the mother?
I was not.
Okay, non-present present.
It would be the punitive or alleged father.
You're not alleged. Oh, you are alleged because they are alleging you're the father. So okay,
Well, I'm already we've already got the three-party parentage stuff going already. So I already have my legal status.
sue to um, what's it called? What's it called when you like when you
Paternity fraud?
no, forget the that's not a fraud at this point. To what do they call the person to that's say you take a paternity test and they um disclude the other party and they disclude you as a father or whatever. Uh, Um, oh, what's the damn word? Can an
Oh,
alleged can an alleged oh no, you're not even alleged. Can a what? You're not even presumptive father. Can a biological father? There, yeah, putative, right? Is there?
because
Yes,
it's a complex process, often limited to within 4 years of the child's
which
birth,
I think
unless
we've
it's
already established.
yes, yes. So again, my issue is multifaceted, and that's so determining.
I think you're making it multifaceted. Um, when I think you can go just directly and get it done. It if it were me, I would resolve the matter. And if I wanted to do something different after I get what I want.
Yeah, so what I want, I said this, I want to be made whole with respect to the way that the state intervened into my case and botched my case. So
But did they
that's a whole nother component to it, which is
but
malicious
hold on,
prosecution.
did they botch your case or did you refuse part of the process and waive that defense or waive a right?
I so that is a potential thing that we can explore, but I'm
We
I'm
we
I, what?
we
Yeah, we can explore it as in a conversation. I'm saying
oh
because you're saying that I might have botched my own case by
no, no, never said that. I said that if
oh,
it were me, I would take the most direct path to get what I am seeking. And I don't think it's a Title 4D case, Ron. I sent you that if you email me, you could ask him directly, Ron, and also create a different kind of discussion, but or an expansive discussion. But what I think is you're not worried about the Title 4D issue. You're worried about parentage, correct?
there I don't know, there's nuance to that. So they
No,
did
is there a Title 4D proceeding?
after this is a component to the domestic violence. So after I opened up a case, she filed after I opened up the case, 7 months into the case of her delaying the case, she went and filed for child support.
Okay, stop. So she filed for child support alleging that you're the father?
After she refused, and I had to go to court to force
Wait.
her to
Just
do the
answer the
genetic
question.
test.
Did she challenge for child support after you were determined to be the father?
No, it was because my case was drawn out, partly because of her and partly because of the state. She ended up refusing to do the genetic test, which I had to involve the court to order genetic
Did
testing
he file for child support before or after you were determined?
before
Okay,
before.
stop. So now, so she alleged that you are the father, correct?
There's more nuance. You keep on asking me a simple question when it's more nuanced.
But no, but okay, listen. What may be nuanced is what you want to discover. What I would not argue is nuance is that your case is not that I don't see your case being nuanced. I think that what you're trying to do might be nuanced. I think what you, if it were me, and I think you would get a lot out of a 30-minute conversation with an attorney, potentially. But if you
Did
didn't
I
want
not tell you how much money I spent on an attorney
okay,
already
I
on
don't want to. I don't want
two
to get into
separate
that.
attorneys?
I don't want to. I don't say nothing disparaging about attorneys.
I do.
I had to put it out. I just put it out there. If it were me, I would go directly. And what about you, Ron Love? If it were me, I would go directly toward what I'm looking for. And then if I wanted to create something brand new, then I would. And I'm not going anywhere. Then I would come back and do all this other stuff. If that makes
I,
sense
I
to you.
I think you think that that's not what I initially tried to do with my case, and thinking that it would only take.
I know you refuse to go through mediation.
No, but you don't know that I actually tried to get in mediation before I even opened my before I filed my case and then paid for mediation, and she refused.
Who refused?
The mother and the presumed father, or it would be the it wouldn't be the presumed, yeah, it would be the presumed father because he through marriage.
So
So
he was
they refused when I was trying to hurry up and get a part of my and be a part of my child's life.
okay.
And
So
then
here we go. Here we go. Now it's getting clearer to me, and I think that we can probably get you some sort of assistance and getting you where you want to be. I believe, from what I'm hearing, and based upon what we've gotten to this far, because I know we don't want to bore people. No, 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 Ron. You can actually answer inside the chat room too, can't you, Macadamia?
is it on YouTube or
Yes,
in here?
on YouTube. Ron is asking us questions.
Let me
Um,
see.
if
Let me see. So the burden is extremely high for
go down to the
well, yeah,
bottom.
no. Oh,
Yeah.
let me see.
And when he asks you how you injure, I think where he's going to is back to the claim issue. And you already know that you can actually bring this claim.
I do,
If it
yeah.
were, okay, but if it were me, I would see how to bring the claim.
Well, so
Forget the new
I
law,
have.
forget everything else. Go straight to what are the facts and how do the facts lead you to determine that something was done or what specifically was done. Okay, can a biological father sue to have a presumptive father removed as a parent under Washington law? Yes. So why don't you do that? Okay, Ron.
Because I'm not trying to get my my priorities switched around. So my first priority is to cl clarify whether I'm the father, because if I'm not, like, my only interest in the whole litigation is if I'm the father.
Okay, stop
Or
right there. Whoa, 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 whoa. I think I already answered this question. It's in the law. How does a non well actually you've been how does you're a non-presumptive father. Otherwise not a non-presumptive father challenge paternity.
it would have to be through a second
Well,
genetic
I
test.
don't need you to tell me when there is a presumptive father via marriage.
Sure, I don't have a problem. I understand all that you're bringing up right now. Well, like
He, come on, Johnny.
one component to this is that disestablishing your certain rights doesn't preclude you from other responsibilities. And I've done a little bit of research on this too, because there have been fathers in the past in Washington State and in other states like Pennsylvania where they disestablish, which the courts change that into, instead of it being disestablishing, it's you're waiving your parental custodial rights, but you still have responsibilities for child support. So so that's something that I want to make sure that doesn't happen to me, which I'm not even, so if I am the father, I want full custody. I've already expressed that component to it. But if I'm not the father, then I'm suing for damages for putting me through all this for no darn reason.
Hold on.
So that's why I'm saying it's multifaceted, depending on what the facts of the case actually end up being once we get into discovery in a court that's actually going to allow me to conduct my lawsuit.
But you had to, in order to sue for a malicious prosecution or abuse of process, one
Mhm.
has to win on some other issue. There you go.
She did, the state did win. They ended up getting the child support award to the state. Wait, I need to make that bigger. Let me see. Actually, let me just put it on this screen. Yes, a father can petition the court for disestablishment of paternity and vacate child support. Typically file. Okay, but there's case law already in Division 2, which is where I'm at in Washington State, that says that you can ask to waive, you can that type of petition ends up being construed as you waiving your custodial rights, but not waiving your rights, especially if the mother is on public health or public assistance. Voluntary assuming the duty. The key is proven that he is not the biological father. So that's one component to, I understand that. Engage in specific actions, prevent disestablishment after knowing it wasn't.
Go back to your first one. If it were me and I did not want to go to an attorney for whatever reason, whatever your reason is, I don't care. I would probably want to lay out facts in my claim that would specifically push the trier of fact to determine that the individual claiming to be the father cannot be the father for a specific set of reasons. Um, what's an AOP, Ron Love? Oh,
Acknowledgement of
acknowledgement of
paternity.
paternity.
No, I did not sign an AOP. We had to go through an adjudicative process.
Okay, so now what I would, if there's an adjudicative process, that means it would have been based upon some set of facts.
Yeah, so hopefully you read some of it, but I was initially appealing because despite your disbelief, there is three legal parents allowed in Washington State, and that's exactly what
That
ended up
that
happening.
that's not the issue for me. The
Well, it is
question
for
is,
me.
no, 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 no. There can be three. What you want to do is I'm guessing you want to either disestablish yourself or the other guy as a as a father,
Well,
as a parent.
at this point, it's potentially disestablishing both of them, so I could just be left alone. But I
Wait,
hear what
wait,
you're
wait,
saying.
wait. You can't disestablish the mother. You could disestablish the father
Why do you say that you can't disestablish you?
because she is the
Why,
mother. Because she is the mother. That's not in question.
that that's not the way that's not how that works, but I hear what you're saying.
Whoa, 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 whoa.
Are you stating that a biological parent, mother or father, cannot lose their parental rights?
No, that's not what you said. You say losing rights. You said disestablish her as the parent.
What is disestablishment outside of losing your parental rights?
I thought you mean like she's not the mother. So that's
No, no,
different.
no.
Okay, so
That is the wildest. I would
okay,
never. That's the
okay, so
wildest thing you got.
you want to um bring an action that would um
It would be terminating her.
terminating her parental rights. That's
Yeah.
totally different now. Now I get that. Okay.
So
Now you had to bring in some sort of fitness test. Now you're getting into a whole nother another set of arguments. I'm not even arguing that you shouldn't do that. I don't even care. But what it sounds like to me is you have a pathway to remedy that you don't want to take
Who
because you
said I don't
want.
want to take it? So I went through my first lawyer and they
Okay,
wouldn't even hear
we're
me
gonna bring up
out.
the
The
lawyer.
second lawyer wouldn't hear me out.
I don't want to hear the lawyer. I don't hear nothing but bad about the lawyer. But I guess tell your story. Tell your story. I don't hear nothing bad about the lawyers. Particularly with my situation. But go ahead. I say nothing disparaging about attorneys, but I won't refuse to allow you to speak to whatever your issues are. But the views and opinions expressed by Macadamia do not represent those of GDNAPSC or myself, and change your name to Macadamia. But anyway,
I don't care if people know who I
good.
am. No, I don't have. So like, I know that there are good lawyers out there. Like I've seen some in court myself, and
And
I've
you know there's
also
a bad clients too, right?
for sure, for sure, I understand that too. Um, but in my particular case, I wanted to make more nuanced arguments, and they didn't want to hear me out, and they didn't want to
I
even.
understand that because you know attorneys have obligations that if they can't bring an attorney by rule is not supposed to bring a frivolous action or defend one. Look
Are
that
you?
up.
I'm no, I already I've read what it means to bring a frivolous what is a frivolous or like I've also read into
Or
like abuse of
he can refuse to bring an action. He can refuse to represent you.
but that's not what they did. They took my money and then didn't do anything.
Ow! I don't want to hear that.
So
Because what was
that's
it?
but those are separate issues. Those are
Thank you.
separate issues.
Thank you.
Those are separate issues that are only tangentially important to my case.
Interesting.
But um so the things that you just looked up are the things that I wanted to talk to my lawyer about, my previous lawyers about, to see what my options were. They weren't interested in that. And they said that the courts aren't interested in that either.
Ah,
And and so that's the biggest issue when I think about how we started this conversation. It's not necessarily the case that even in some jurisdictions in Washington State, my claim would be easier or more reasonable. It would be received better. But in particular, in Pierce County is the largest county contributing to the Title IV-D program in Washington State. So, we don't need to belabor that component to it, but after seeing the outcome of my final litigation and my final orders and how my case was closed, the only thing that they really wanted was to secure those support orders. And everything else that I brought, all of the other evidence that I brought to the record, and all the other allegations, they were not considered. So that's a big reason why, I eventually want to bring forward my perspective and my legal arguments to shift it into the federal courts so I can get a fair trial or at least a fair finder of fact so I can, make my case. And if I don't get my relief at this level, then I take it to the next level or the next level. But as I told you that I just wanted to go to the Supreme Court, the specifics of my case actually give me that ability to go to the Supreme Court because three-party parentage is a new legal concept, and they should want to hear about this, the
they
debauchery going on in
should.
my house.
Isn't you? So you're asking them about discretionary review. What's going on? Isaac ain't playing.
What did you say? Sorry.
I said, but you're saying they should. You're saying that a body with discretionary review power should want to hear something.
Yeah, so that's what I would be telling them, explaining to them. One is, why I shouldn't be held to the standard of having to exhaust my administrative remedies, which we know that we typically have to go through the state courts, then work your way through the federal courts, then you get your way and you're
Oh,
right.
but what are but everything that you have asked about, we have the answer to getting you an answer. Every issue you've raised, and thank everybody who's still with us or who may be watching this. I don't know how far in we're in. I don't have a timer on, but every issue that you've raised, we've found a definitive answer. And I would say this, I mean, yeah. I said, how long have you been with us? I'm saying this. If it were me, and I would say this to anybody, I would take this approach, and because I think that you have again, there's a vehicle for you to get what you want from what we looked up. Apparently, you can go take. You could even say, "Hey, listen, I'll pay you 2 hours or whatever his rate is as a consult. I want you to watch this video. If an attorney would do that, and tell me what am I missing that would help me get what I want." If you want to, and I think you're trying to ask to change law that benefits you, or you're even asking to do something that already exists. If it were me, I would resolve my matter through the process that I see that we found benefits you. And then if I want to do something else, I would go to that. If I want to create, if I want to bang the concrete or hit pound the pavement to get some sort of law done that even better streamlines what your issue might be, that might be something. And it may be something that they could do pretty simply. But before I go and say, I want to make them do this, fix your problem first and then go to the next thing. It'd be like, here's an example. Before I could sue for malicious prosecution because the city of Tampa's police department, Gregory Holder, did what they did, I had to win the perjury. I had to get rid of the perjury charge first. I couldn't say, oh, I'm gonna sue y'all and go ahead and sue in federal court, which I did sue in federal court, and do all this other stuff. I'm not arguing that you don't have an abusive process. I'm not arguing anything else. I just think that you're taking the long way around something. What's this, the shortest path distance between 2 points is a straight line. You're squiggling all of that shit. It's like right here, I can get to right here, but let me do all this and go down here and around. Get your remedy, then attack everything else. I'm not an attorney. I don't pretend to be one. But if it were me and I want to disestablish a presumptive father from a birth certificate or from parentage, and I have a set of facts that would be easily articulated to show why, based upon what the rules state I had to do, no. There you go. If he's a presumptive father in this complex, I file my petition. We do it within the 4 years. Exceptions, if the child's over 4, the court may still intervene if the presumed father is not a genetic parent. That is the only issue I think you have. That's it. Can I show that the person who's the presumptive father cannot be the genetic father based upon the fact that he didn't get married with he did not get married to he married the mother after she was 6 months pregnant, and I have this set of facts to show that he didn't know the mother, whatever it is, or simply I can sue for to show that I'm a a presumptive biological father, which you are because of the child support action, because she's claimed that you're the father. You're presumptive and go into the other direction. Just get rid of the guy. And then if you want to say the state had some duty that they failed and that you may not be able to sue the state anyway, because you may have to see if the state has a waiver of sovereign immunity under state law.
It does. It does.
Okay, so the state does, okay. And I'm not giving it as legal advice, I'm just saying it's something I would think about. And then what I would do is say, based upon these sets of facts, I got to hear something moving. These sets of facts, I would remove that guy and say the state may have harmed me, or whatever it could be. They would allow you to waive it if you want to sue the state later. But before you could sue the state, you have to show that something else took place that should not have taken place. Like the state should never have What made him the
intervened in the
presumptive father?
first place. They
Okay,
shouldn't even jumped into my judicial
but
case in
did
the
but
first.
did the state? What was the state? The state does have a right to intervene if it's for the interest of the child, though, because I think you're looking at you, the mother, and this dude as if the child doesn't have any rights, and the state does have rights to the child. Remember, to look out for
Yeah,
the best.
I get that, but the state, well,
Okay,
if
here we
this,
go.
I understand. I've read the statutes that allow for it, but even if the state jumps in, there has to be a guardian ad litem because the state has an inherent interest in child support. That's why we have to have guardian ad litems in Washington State to represent the interest of the child separate from the state.
Mhm.
And this is another component to the misconduct that I'll be alleging in my next legal stint. Yeah, the child has a party. I'm tracking. Guardian ad litem does not have to be appointed in every challenge of presumptive father, but the court must appoint one if they find the child's interests are not adequately. Yeah, so if both of the parents are presumed to be not acting in the best interest of the child, then a guardian ad litem has to be appointed.
But the court must appoint one. Must
And
appoint one.
and I
If
have two different ones.
it does, if that's not okay. Then your question is, can a court appoint more than one guardian ad litem?
No, it's not. It's already been done. Like I'm not tripping about that.
Okay,
Well,
so
I
now,
am tripping. I am tripping, but for
well,
separate reasons.
well,
Like these are not my you think I'm doing this? These are just the various procedural things that happen where I know that the procedure should have just went from point A to point B, which should have been, am I the genetic father? If I am, then I have rights and we need to establish custodial rights and then child support.
hold
So
on.
that's how it should have been point A to point B. It didn't do that, and I didn't make all this, Greg. I,
Okay,
I
I
I
get
didn't do
that.
all this.
Let me ask you a question. Have you moved to disestablish him as the father?
No, not yet.
Okay,
That's the next process, but it's understanding the nuance with regards to that,
okay.
which would have to go into like you were saying. So you pointed out if I wanted to move to terminate the rights
No,
of the
no,
mother,
I'm trying to
it
figure
would
out what
basically be the
specifically do
same
you what
process.
specifically do you want from the court?
So my next lawsuit, I have to understand what the final conclusion is.
No,
So
to
that's why I
what?
said
Conclusion to what though, bro? To
so
what?
a lawsuit has to come to a conclusion. I can't just make a
No,
lawsuit.
no, 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 no. Forget the lawsuit. Forget filing a lawsuit. What do you want the court to determine as a basis for you filing a lawsuit?
So you want the fact pattern that I want them to
No, no,
validate?
no, 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 no. What do you, okay, do you want the court to disestablish him as the father?
Uh, if I am the father, sure.
Okay, so
I don't
if
give
you
a,
are,
I don't if I'm not the father, I don't care if he's the father or not,
okay, so then what you want the court to do is determine if you're the father.
based off genetics, because you can be a
Okay,
legal
okay.
father
I
from
get that. I just said you want them to prove. Okay, we've already gone through that. So you want the court to make a clear determination as to whether or not you are the or not the sole biological father of the child.
yes with the
Well, I mean,
second genetic test.
you have to be the sole biological. You want because you're not a cat or some other kind of animal. You want, and there's no twins involved. So you want the court to make a determination as to whether or not you, as the alleged biological
I'm
father,
not the
are
alleged anymore. I'm not the
okay.
alleged anymore.
So then all you want the court to do is to disestablish him as the father.
No, that's not the case. I've tried to explain to you the fraud associated with my case when we're
No,
talking about all this
I
stuff,
get all
and
that.
it makes me concerned about the actual legitimacy of the first genetic test. So I want to do a second genetic test to affirm that. And then if that's the
That would mean that you want the court to disestablish him as the father.
which is the next step. It's the next step. So you asked me, what do I want? The
I
first
believe it. I
thing
believe it's a part of the. I believe it's a part of the same thing.
but it turns into something else because once I am affirmed about my the truth of my genetic lineage to the child in question, then I have to go into like that best interest factors because the reason why they deemed him as a third party parent is because of the quote unquote best interest of the child. So
Okay.
that's a nebulous term anyways, that's
Okay.
not
Hold on.
defined.
Okay. Okay.
So if
Okay.
you were asking me what else I would want a higher court to determine is the best interest factors for three-party parentage in parentage cases outside of the de facto parentage statutes, because those are defined, but they didn't even reference those when they made the determination.
Deny biological father rights over his child without due process and
Well, I already, oh, okay, let you finish that. Hold on, I'll be right back. I have to go take a piss real quick.
okay, he just told the whole world. He just said I'll be back. Okay,
All right. Oh, before you wait, let's see. What did you put in there? So cannot deny biological father is fundamental parent. All right. Okay, so I've actually literally Googled this before, but it led me down the path that the due process clause of the 14th Amendment, actually those protections aren't afforded to a father in my particular situation. So the Supreme Court has already ruled that in order for you to seek the protections under the 14th Amendment as a father, you one either need to marry the mother or two establish an actual relationship with the child. I wasn't able to do either one of those things, which is part of the reason why I'm making that tort claim of interference. So
wait. You went to the federal law when the
what
Washington state law says this?
say that one more time?
Um,
So you asked me, I went to the Supreme Court law to see how the 14th Amendment is applied? Yes.
okay, but do you read the Washington in Washington state, the court cannot deny biological father the fundamental right, parental rights without due process.
Okay, so
No, this is on
up
any
until my
okay.
final orders, I was nothing. I was the alleged father, so I didn't have rights. So the potential claim that they have in defense is that I wasn't the biological father until a year and a half, almost 2 years, when I actually got the legal determination that I was the biological father.
Which makes you the father back to day one, back to preconception. I mean, back to conception.
I don't know. I don't know if that's how the law works. I actually don't know that. That's part of my question. I don't know if it. So if if I am deemed 2 years after um
Hold on, hold
two
on,
years after this
hold on,
birth.
hold on.
the date it's legally established. So it doesn't do dictation meaning it cannot be established.
You know what I noticed that a lot of people do? Y'all, I'm about to cuss on my thing. I don't want to do that. Y'all don't read through to the end. And then we go ahead and say, because this right here is just what we're going to use in order to go through the
Sure.
process going back to here. And we start to deal with it through our research. If it were me, there's no deadline, but the parentage date depends upon the method used to establish it with with early action securing benefits and avoiding future complications which you're already in. But um you didn't do an acknowledgement.
I attempted, that's going to be a part of the elements of my tortious interference. She refused to because if I did the acknowledgement of paternity, she would have to sign it in Washington State. It's not just a father signing it. The mother has to sign it. But then because there is a presumptive father, he would have to sign a denial of parentage. And she also refused to facilitate that because she knew that there could be three legal parents. So that's why she frustrated the
Wait,
process.
you're speaking to state of mind, but this is if it were me, and I'm sure you can go ask an attorney. Did you, oh, let me ask you this question. Did you ask the court to compel her to do anything?
I wanted to go to trial because I was disputing. No, no, to answer your question directly, the only thing that I had the court do a compulsory order for it was the genetic testing.
Okay, so now you've had genetic testing, and the genetic testing has determined that you are the biological contributor to the child, and now you've been established as a father of the child. It just seems to me that you're standing in your own way. I'm not saying that all this other stuff you want to prove can't be proven. It just seems to me that it would make more sense to one, either have a second genetic testing. Let's try this right here. You're not presumptive father, is a biological. There you go.
Yeah, I already know both of the state statute and the federal statute that I'll be using.
Okay, so if it were me, oh guys, forget if it's me. I want to ask you a question. Why don't you just ask for the second genetic testing?
Because I need to file, I would need to file a lawsuit, but then I need to allege everything that I need to allege, and I can't, I'm not interested. Dispute result, evidence, new
because
evidence.
I'm just thinking that we presume things that I think you could probably just go find the direct answer to.
Well,
All I'm trying to do is get you
what I
to.
already know, Greg, is that I can't just bring I'm not interested in just bringing a singular motion to do the genetic testing without also making the other allegations very clear. Because one aspect is like the first thing that I think that I need to do is they haven't started garnishing my wages, even though they've sent me like five different notices that they're going to, um, is to get an emergency stay on that. And then so injunctive relief is my first thing that I would like to do. And the next thing would be the motion for a second genetic test.
But why? Why are you going backwards? Okay, let me ask you this question. Why you need a second genetic test? Are you disputing that you're the father?
Potentially because of all the fraud that I keep on bringing up, which I understand are separate and tangential, but they're the reason to sow doubt. And there's other aspects to the conception that are elements to that I'll be bringing up as well.
Why?
Oh, why do you call me white macadamia nut? And well, you
I'm
know
asking
exactly.
what no, why? Okay, if you're not contesting, okay, if you want to contest the results of a genetic test, you have a path to do that. That's
Yes.
okay. So let's, because when I get ready to close this, I want to make sure to contest or dispute contest, dispute, or verify, right?
That would be what that motion would be to do, yeah. Or the after we got those results.
You already had the results. So now you want to either contest, dispute, or verify the first genetic test.
Yes.
Okay. If you are the father, if yes, you then want to A, disestablish paternity for the other father, right?
Yes.
And then if you can prove those two, you want to what, vacate any child support orders or what? What's your next thing?
It would be to worry about custody to establish custody and stuff. But it
You
would
want
be
to
to
step.
it would need to the procedurally I think it need to go to vacate the child
No,
support
I just want to know
until
what I just want to know what you want to do. So
yeah,
I'm writing this down.
cus
You
it
want
would be to get custody and it would be
to
full custody.
full or whatever, or an alternative, a reasonable time sharing or time sharing thing, right?
Yeah, so that would be step two in my perspective.
Okay, so now this is just me. Given what you said, it would make if it were me, I would do those things and then move on to all the other like psychedelic things that you seem to want to do.
Psychedelic, this guy.
Because I think you have a clearer path. It's almost like it's like you want to do a reverse 360 dunk, but you have a 22-inch vertical. And I'm like, why don't you just get the bucket and come on back and get the 2 points and go play defense? Now, I'm not saying that you only have a 22-inch vertical. Maybe on one jump you might go 42 inches, and that's enough to clear the rim. I don't know how tall you are, but it would seem to make sense if you want to win the game and you know you can hit this layup. Let me just go lay this joke off the glass and get on back and play defense.
I don't have a problem with that. I don't have a problem with the analogy, but it's different if the referees have
Forget the referees. Play your
you
game.
you can't be
No,
you can't
no.
be serious by saying that. You can't be serious that you think that thinking that you're playing a fair game
Well, let me ask you a
of
question.
basketball
Okay, hold on. Have you contested or disputed the first test?
contested or no, we know this we have not yet.
No,
Oh,
no,
I
no.
have not.
We ain't okay. There you go. Okay, now, so if you want to contest, dispute, or um verify the first test, wouldn't it make sense to do that?
Yeah, so then that leads us down the conversation that I wanted to
Whoa, 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 whoa.
argue with you is in what venue do I want to do that in?
Whatever venue you would have to. We just went through all that, and actually, this is on national view. So here we
That
go.
no, we didn't. I told you that I wanted to go to the Supreme Court to have this all
I
litigated
get, I
out.
get, okay. You may want to do all that litigated through the Supreme Court, but what's the steps to get to the Supreme Court? You had to,
Uh, Petition to them and make the alleged fact pattern that invokes
no,
their jurisdiction.
I don't think it's, oh wait, I don't think the Washington Supreme Court does that way. Okay, hold on, hold.
No, 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 not the Washington, the United States
Oh,
Supreme
you're
Court.
not okay. So, but what's going to be? But you got to bring a case in a lower court to get to the United States
I
Supreme
don't
Court.
because I already have a final judgment that so you actually can't use the federal courts as an appellate process
Exactly.
in family courts. But the Supreme Court has the sole jurisdiction to review any court's decision in the United States if they have the interest in doing so, which is my
It's called
argument with
certiorari. I
I
know
think
it's
it
called
still is a
certiorari.
certiorari. Important federal questions.
What's your federal question?
You didn't like it. You thought it
Well,
was
no, no, no. I
inflammatory.
know it doesn't matter what it is. I'm asking you now for the people who are here.
Yeah, so as I expressed that the tortious interference statute in Washington State is in the same cluster of statutes that are what would be the statutory prohibitions against slavery. So I'm going to be making a slavery argument or pecuniary peonage, whatever you want to call it, involuntary servitude. I'll be making those arguments and showing how,
What would make your what's the involuntary servitude?
yeah, it would be the inducement associated with a couple different elements of the case.
Bro, I know you're not serious.
I'm being 1 bazillion, one
Okay.
bazillion percent.
Okay. I'll let me know how that one works out. But anyway, so giving everybody about an hour and some change, I'm guessing. So what I will say is we may come back with a second consideration of the nuance between Macadamia and Greg, but we're going to hope that in between then you're going to dispute the contest dispute or verify the first genetic testing. And if you are the father, I'm hoping that you're going to want to disestablish the other father as disestablish the parentage or parental rights of the other father, and then you want to seek custody of your son or get some sort of time sharing agreement, is what I'm gathering from all this. And I'm sure that you're going to utilize some of the information that we pulled up today that may be beneficial to people in other areas. Um, that being said, any shout outs you want to give before I close this out?
No, I just appreciate your time, and
Oh
I
man,
hope there is a second video, so we can go down, because I still want to talk about, we can get into the specifics of child support because I know that that's a big topic for most people, and we can go through my financial affidavit and talk about how um, I think, or at least the law says that child support should be established in my situation, and clarify, at least in Washington State, what the statutes say. We can read the statutes or whatever and establish based off the facts of my situation what I should be arguing for child support if it gets to that point.
okay. And except the judicial proceeding is interesting. Um, that being said, and that's pretty interesting. I'll say in closing, sometimes it's not about right or wrong. More importantly, it's about clarity. You never reach resolution if you're not willing to engage in honest dialogue, even if that dialogue is with yourself. Take time to hug the person you love and love the person you hug. On behalf of GD non-attorney pro se consultants, I'm Greg Doss. We were joined in our first episode of Greg and Macadamia discuss pro se nuance. I'm saying peace. I'm saying chicken grease, and because today is the 31st day of December 2025. If you have any ambitions or plans to go out or do whatever and celebrate the new year, we hope that everybody is safe and does the safe things because there's people who care about you. I'm out.